Hello everyone, welcome back to our video update. It's Sade. Today's video is going to cover the question relating to junior lien holders and what happens when there are excess proceeds from a foreclosure sale, but there are some junior lien holders. So typically this question comes in the context of a homeowner whose property went to foreclosure sale because of failure to pay property taxes. And let's say that homeowner was not paying the property taxes, but also had a mortgage on the home and possibly was paying the mortgage. So the mortgage lender didn't really notice about the property taxes. It's possible sometimes because not everybody pays their property taxes through their mortgage payments. So let's say that the tax office in that county went ahead and did a foreclosure, but there was still a mortgage loan hanging out there on that property. That means that the collateral is gone, right? The tax office sold the property off so that the mortgage is still there, which is the debt obligation, but the collateral that was securing that loan is gone. So then the question is, what happens at that point if there are excess proceeds left over from the sale? So let's say I had a piece of property and I was paying on the property as far as my mortgage payments, but somehow I wasn't able to pay my tax payments, and then the county took the property and sold it. So the property in this example, let's say it was sold for $200,000, but I only owed $10,000 on my taxes. So then there's $190,000 left over, which we call excess proceeds, right? So the excess proceeds rightfully belong to someone. They don't belong to the county unless the claim period has completely expired. And the claim period in Texas for those types of sales is 2 years. So that money, $190,000, belongs to someone, but who exactly? So that's what this question is trying to figure out. It belongs to several people in order of priority according to the tax code. And so it will belong to some other taxing agencies that might have been owed money, but they didn't get that money right before the sale. So they could still put in a petition and collect the taxes owed. It also could belong to the mortgage lender because the mortgage lender's debt is still hanging out there, even though there's no longer a collateral for it. So let's say I still owed on my mortgage $100,000 at the time that tax foreclosure happened. Then that means that the mortgage lender could apply to get $100,000 from those excess proceeds. And then I will get the remaining $90,000. So that's how it works. Now, what if I, as the property owner, would like to claim all of the $190,000? Can I do that? So that's the related question that people want to know. And the answer is yes, you can definitely do that. There are certain procedural steps that have to be taken. And there's a risk that in future, potentially that mortgage lender might come after you for a deficiency on the mortgage loan. I don't think they'll be successful. And the reason why is because there are certain steps in the process where the parties are required to notify the mortgage lender. And if they did that correctly, then the mortgage lender failed to claim the money on time. So that's their loss. So typically they have a notice that's sent out by the county's lawyers when the tax foreclosure lawsuit is filed. It will be sent out to me as a homeowner, and it will also be sent out to my mortgage lender to let them know this is going on if I still have a mortgage on that home. And then that's the time frame in which the mortgage lender has the opportunity to contest the sale, pay off the property taxes so that that property doesn't go to foreclosure. Whatever they need to do, they have a chance to do that while the lawsuit is still pending. Then once the lawsuit is done, they get a notice of judgment, which allows them to appeal the judgment within a certain time period again. So they have chance two. They have several chances along the way in which they can save that property from foreclosure. And if they fail to do so, I would think it will be presumptively taken that they failed to act within the allotted time. And then if after that time frame passes and the excess proceeds, as we gave in this particular example, and I, as the homeowner, went forward to try to claim all of the excess proceeds, I then still have to notify all of the parties before I'm able to claim the funds. So again, the mortgage lender has a chance to intervene and say, wait a minute, we haven't been paid yet. Give us our money. and then you can take the rest. So they have chance after chance after chance to be able to object, to be able to contest, and to be able to claim either the property itself or the excess proceeds, or a portion of the excess proceeds. So that's the short answer to the questions that people are asking regarding junior lien holders. The same goes for every junior lien holder that's identified in the tax lawsuit, in the original tax lawsuit, or any other junior lien holders that might be out there that the property owner knows about. Again, that's procedurally speaking. You could do that and get away with it by claiming all of the excess proceeds as the former owner, as long as you follow all the notice requirements, right? And you follow everything to the T. Now, what happens if I did all of that, got all of the money? Can the mortgage lender then come back and try to get money from me? Of course they can, because I still owe them on the debt obligation. But the thing is, it's unsecured debt at that point. There's no more collateral for them to hang it onto. So they can go after me, get a personal judgment against me. I could file for bankruptcy, right? I mean, that's just the way it is in the United States. The bankruptcy laws are there to protect consumers. And sometimes it's, if I don't have the money anymore, maybe I spend $190,000 for medical bills or whatever it is, and I just don't have the money. They can sue me and get a judgment, but it's not going to be a secured debt at that point. So that's the downside and disadvantage of the lenders ignoring the tax lawsuits when they could have acted sooner. So really, yes, they could come after you after you've taken all of the excess proceeds, but in reality, they probably wouldn't come after you unless it's a ton of money. If it's a ton of money, they could still come after you, but chances are, they may not win that lawsuit, or if they win, it's going to be a personal judgment, and you can still settle it for a fraction of what you actually owe them. So that's my video for you for today. Hopefully that's helpful to you, and hopefully it answers the questions that we get. This is me summarizing it for educational purposes. The actual reality is that there are many, many hoops and I guess gymnastics, the legal gymnastics that the lawyers have to do to be able to get away with something like that. So that's my quick answer for you. Hopefully it's been helpful. And really, this is just me summarizing the legal aspects for educational purposes and illustration purposes only. So in reality, you need a really good litigator, a lawyer that's comfortable in the courtroom, comfortable with pleadings and, interpreting the law and things, and arguing the law, because it's going to be a lot more complex in real life. And at the same time, I needed to explain it in a video, but that's the actual overall process. That's the summary of how it goes. And that's a summary of what the law requires and what the law permits, and what the ultimate outcome could look like for somebody that follows through and makes that kind of a claim, and there's still a junior lien holder out there. So usually they're out of luck, or they can negotiate with you a much smaller settlement than what you actually owe them. All right, hopefully this has been helpful to you. If you like the channel, make sure to click subscribe. And if you like this video, make sure to click like. Thank you so much for watching, as always, and I'll talk to you next time.